the amendment before the previous one. I believe I heard either yourself or other people on your side of the aisle speak essentially that this was a minimal intrusion into the affairs of the corporation. Perhaps it was the other gentleman from Massachusetts who essentially said that. What I would point out is with the gentleman from Florida's amendment, it points out, again, to some extent, what a slippery slope we're on. And as the gentleman from California said, as an investor, I'm looking to invest in really good management to make a number of these decisions, and the ultimate vote I have is, one, the vote for that management and the vote to invest in some other company. And so once we start down the road again of what is going to be required on the federal level, what to be voted on, and then with respect to these First Amendment rights, having the federal government compel the level of disclosure to the shareholder, again, I start to question, why is the federal government in this business in the first place? And another point I would make is, I believe the gentleman from Massachusetts said, the original sponsor of the bill, and I don't recall his exact phrase, but something along the lines of that this is an issue of first enactment or first impression. Instance was the gentleman's phrase, and I agree with that. But in my mind, this is dealing with the First Amendment, and if it is an issue of first impression, I want to err on the side of freedom. I want to act very cautiously in this area. So I understand the argument, well, that the chairman makes, they're going to have to vote on this proxy anyway. But already we're seeing a series of amendments where all of a sudden, you know, the impediment has grown from here to here, and once we set this precedent, you know, how much further is it going to grow? And again, I sincerely believe that the highest of all hurdle rates needs to be set. I'm not saying there aren't exceptions. I'm not saying that we don't set them. But the highest hurdle rates have to be set, and I do believe that the corporate entity does have, as the Supreme Court has said, political rights of free speech under our First Amendment. Frankly, I wish they were broader than they are. Not that I necessarily agree with the broad view of corporate interest. It's been my experience in Washington that many corporations, for example, believe in competition for the products that they buy. They just don't believe in the products that they sell. That runs contrary to my free market principles, my free market philosophy that I try to further in principle in this body. And so I would hope that we would reject the gentleman's from Florida's amendment. Again, it takes us down to a slippery slope. And then back to the previous subject, I continue to be concerned about the lack of parity for the labor union entity. And if these are such minimal intrusions, and if these are so important, I'm not sure that there's any facet of this debate from the proponents that is not applicable to the labor union entity as well. And so, again, I hope to be offering an amendment. I hope that it is going to be found in order that attempts to achieve this parity. And if it doesn't, I hope that those who are as passionate that the corporate entity has to have these restrictions, these reporting requirements, I hope they will show equal enthusiasm, commitment, sincerity to ensure that the labor union entity receives, and the members receive the benefits that are purported to go to the shareholder. And certainly either today or in the days to come, members on the Democratic side of the aisle will have that opportunity. Yield back the balance.